No reason to unmute or start your cameras. This is just the staff attorney letting you know I've received communication from Judge Krause that she's running a few minutes late and expects to be on momentarily. Thank you.
Good morning.
Morning, Judge.
Sorry, I'm still apparently logged in as Chiquita Johnson with a photo of Mitchell Freehoff, so it's all very confusing, but I really thank you all for being here this morning. The reason the reason this calendar was set at all was because this case was one that seemed to be in the very last stages of being fully resolved. And just in an effort to continue to prompt the parties to make those final decisions, I wanted to have this case. I also appreciate, there's Ms. Cummings. I also appreciate, forgive me, I don't know if it was Mr. Howard. I think it was Mr. Howard that sent me a nice summary of where the case is generally. And I agree with the outline of what he sent, except that the city of Atlanta has already been dismissed. So they don't really have any dog in the fight at this point. And they were very aggressive about getting out of this case. So they got out. Having said that, as I understand what's left is Ms. Cummings' right to assert a claim for attorney's fees if she chooses. And then any claims that Kelco, now that they've been admitted into the case, might have. And it seems to me as if all of this should be wrapped up by now. And so basically, I was hoping to get on the call and y'all tell me, all done, we're good, Judge. Mr. Henderson, you're nodding. Go ahead. Why don't you start?
I had hoped the same, Your Honor. I circulated a draft yesterday of a voluntary dismissal of all claims by the parties. I feel like I'm kind of the third wheel here, to be honest. I don't have any claims that I want to continue to assert. We have the property. It's titled to us. We're not seeking fees from anyone. We're not seeking anything else from anyone. Really, the dispute, I think, at this point is between Mr. Jones and Ms. Cummings regarding attorney's fees. And I feel like I, to some degree, am locked into remaining in the case until that's determined, because the settlement agreement with Mr. Jones and myself, or not myself, my client, obviously. I apologize, Your Honor, I'm only on my first cup of coffee this morning. So
as am I. So,
but under the terms of the settlement agreement, dismissal of the case against Ms. Cummings was part of that agreement. And so I'm really only here to discuss that issue and to figure out how to extricate myself from this case in a way that doesn't prejudice either of the remaining parties to this.
Okay. Ms. Jett?
Good morning, Your Honor.
Good morning.
I think you've probably reviewed this, so you know I've substituted in as counsel for Mr. Jones whenever Mr. Robinson retired at the end of the year. I agree with Mr. Henderson. There's have no objection to Kelco's removal from the claim and his position that the only remaining claims really are the attorney's fees claims between Mr. Jones and Ms. Cummings. And, working on getting some authority from we've resolved everything as with the property. Property's already been sold. I filed a dismissal of the title and property related claims last week. And I think the sole remaining issues really are the attorney's fees claims between Mr. Howard and my client. I think my client would very much like to not see this litigation continue. So we're just working on some authority on that end for me to make an offer. I was speaking with him, as recently as late yesterday afternoon. So my hope is that, we can have some reasonable discussions and get this resolved, get that last lingering issue resolved in the near future.
Okay. So procedurally, I believe what Mr. Howard outlined, and you might disagree with maybe how it's characterized, but in terms of there's the one claim that Mr. Jones, I believe, still has existing, which is the substantive claim, and then the derivative claim from that would be the 13611 claim. Is that your understanding of what Mr. Jones still has existing?
Well, I didn't draft the original pleadings. I think that's right. I can go back and read the petition and make sure I understand which provision the attorney's fees claims were under. But yeah, there's everything except for the damages claims for attorney's fees have been resolved. So title property is good to go. And so I just think that we probably need, hopefully, just a matter of a few days of Mr. Howard and I speaking and seeing if we can hammer out the remaining issues.
Okay, thank you, Ms. Chat. Mr. Howard?
Yes, Judge.
Anything to add? Go ahead.
My only point is this, Judge. All of the claims in the amended petition have been dismissed except for count 4. And count 4 is a 13611 claim. And I think the law is pretty clear that they cannot maintain a 13611 claim unless it is attached to an independent cause of action. So I think count 4's got to go. They may have some consternation about that, about whether or not they can file a motion for attorney's fees. I won't advise them on that, but I'm not sure that eliminating 13611 would eliminate 91514, for example. I just don't think they have a claim.
Right, I understand. And that's, certainly my general understanding is that having dealt with lots and lots of summary judgment motions that deal, the handling of a 13611 claim is always, well, we went on this, so they can't get fees on 13611. I think Mr. Howard, I'm not ruling on anything, Ms. Jett, but I think Mr. Howard's characterization is pretty accurate, at least as I understand it, that a 13611 claim is derivative of an underlying claim. And when none of those claims exist anymore, then typically what results is the 13611 claim also being dismissed. It is my hope that the parties will come to that agreement on their own through a dismissal as a result of discussion and or negotiation. And I would agree with you, Ms. Jett, that I would hate for us to have to brief that issue, because I think it's one that's fairly straightforward in the law, and that it would be not a good use of the resources of your client or the time of you find lawyers. That's one issue. And then separately, Ms. Cummings, I think through her counsel, has always represented that whether she does actually do it or not, that she was holding onto her the potential to file a 91514 claim for fees, which, as we all know, is a horse of a different color and procedurally postured differently, and one that they can choose to raise or not raise. I agree with you, Ms. Jett, on that issue, that it would extend the litigation because we'd have to litigate that issue. My goal is simply, this case has been hanging out for a long time, at least from my perspective. Y'all might not think so, but and it feels like it needs. I'm hopeful that Ms. Jett is right, that perhaps it's just a few more days of negotiation and we can come to some resolution. But I would very much like for this case to finally go, to finally and fully be resolved, primarily because from my perspective, unless we're talking about motion practice, which we're not, at least, we have not up to this point, largely the issues in this case have all been resolved through the parties, getting together and figuring things out and voluntarily dismissing here and there. And so the only thing left for me to do is say, let's go to trial. And so that's the last sort of quiver I have, or arrow I have in my quiver, to be like, okay, what are you guys doing? As my dad would say, it's time to fish or cut bait. So basically what will happen now is I'm just going to continue to wait for you fine folks to figure out what y'all are doing. I don't have my docket in front of me, so I don't actually know where you guys are procedurally, if there's any discovery or anything left. But what you can expect, whether it actually will be needed to be done in any way, is probably the next thing that will happen is y'all just going to get set on a trial calendar with a pretrial conference that'll be 3 weeks before that. And then hopefully y'all would resolve the case from there. What are your thoughts about, or should I just schedule another hearing? What do we think? Ms. Jett, Mr. Howard?
I have a thought. If Ms. Jett
Yes, sir.
wants to go first, I'm happy to hear it, though.
No, go ahead.
Judge, I think that I don't think there's actually any standing for this case, and therefore I don't think there's actually any subject matter for this case. So I think it would be a problem to be set on a trial calendar for a case where there's no subject matter jurisdiction. There's no live case in controversy. There wasn't when the case started, because, as we all know now, Mr. Jones didn't own the property. And then there isn't now because Mr. Jones doesn't own the property, as everyone admits. Mr. Henderson's client is voluntarily dismissing claims that he has to quiet title, but he intervened into a lawsuit in which, by the time he intervened, there actually wasn't subject matter jurisdiction because there was no standing. So this lawsuit essentially doesn't exist, or shouldn't, and it just needs to be cleaned up off the court's docket. So that's my thoughts on it. I know that's maybe a little annoying and law school-y, but that's
no, it doesn't bother me. It just sounds a lot like motion practice that we're going to have to engage in unless everybody agrees. So, Ms. Jett, what are your thoughts?
Your Honor, I'll just kind of, not to repeat myself, but I feel like this is a case that can and should be resolved. And it's just, hopefully just a matter of some brief conversations between Mr. Howard and I to see what we can resolve. I also agree that Mr. Henderson does not need to be dragged along through this. So if there's, something that can be done today that can just go ahead and, get Kelco out, I'm certainly not opposed to that and have no desire to kind of drag them along with that. But I really don't think that this is a long drawn out process to figure out, what Mr. Jones and Ms. Cummings are gonna do.
All evidence to the contrary, Ms. Jett. I mean, really and truly, and not by your fault in any way, but really and truly, despite the, involvement of the city of Atlanta and the involvement of Kelco, at the end of the day, this is a dispute between Mr. Jones and Ms. Cummings that could have been resolved a long time ago.
Oh, 100%.
And yet it still isn't. And so really what I'm looking for is at least one thing. I think we are all in agreement on the posture of the case. Ms. Jett, I understand your mentioning Mr. Henderson's client and him being dragged along. I don't know, given the terms of a settlement agreement, that I don't know that there would be agreement to allow him to get out of the case until the rest of the case is fully resolved. But that's something that y'all can present to me if I'm wrong about that. I'm really just trying to make sure that we agree on the procedural posture of the case, which is that the only two parties left in this case officially are Mr. Jones and Ms. Cummings, and that the only two issues that remain, assuming I have any jurisdiction, Mr. Howard, right, is to figure out what to do with that 13-611 claim that was originally asserted by Mr. Jones, and is no longer supported by any other cause of action, and whether or not, upon ruling on such final or close to final disposition of the case, I am then 9-15-14 motion then gets filed by Ms. Cummings, which is what I expect will happen absent some agreement between Ms. Cummings and Mr. Jones. And so my goal is just to keep the matter moving. And so, if I just set this for another hearing in, 2 weeks, 3 weeks, then at least that will get, I mean, what I have found, not that you guys don't all work very hard, but y'all have lots of things, and sometimes it takes somebody else making you put this one front and center. And so that's why I just keep setting it for hearings, because then y'all don't have any choice but to say, oh, what's going on with this case? Let's figure it out. So that's kind of what I'm going to do, is just be a burr in y'all's saddle until y'all tell me that y'all are ready to stop. Mr. Howard, maybe you're right. I shouldn't put it on a trial calendar, but perhaps a hearing calendar, maybe 3 weeks from now, and see. Obviously, if you guys come to some resolution before then and let me know, I'm happy to remove it from the calendar. But just as a way to keep it on the front burner for everyone. What are your thoughts on that, Mr. Howard?
Judge, my thoughts are, if you entered an order today dismissing the case because there's no case currently pending between the party, no substantive case, that would set a 45-day time for Ms. Cummings to file her 915-14 motion. If the conversation between Ms. Cummings and Mr. Jones are really going to be brief, they can happen during that window. And then what Your Honor will have is a clean docket, and you'll either get a 915-14 motion or not. And then we could, but at least at that point, you would not have anything further that you had to do. It would really be up to the parties to settle it or not within 45 days. But I think the case is over.
Ms. Jett?
I mean, I'm still gonna propose the, give us a few days to talk about it, position, so.
Okay, well, I mean, that's fair, and I understand from your client's perspective. Why don't we do this? I'm gonna do what Ms. Jett asked with one caveat. Mr. Howard, will you please send me over a proposed order dismissing the case?
Yes, Judge.
And while I mull over that for the next few days, Ms. Jett, you and Mr. Howard can talk, and y'all's clients can figure out what they want to do. And then today is February the 13th, probably Monday or Tuesday of next week. Monday's a holiday, so probably Tuesday of next week, I will be deciding what I'm going to do on whether or not to dismiss the case or set it for hearing. And so what you would then get from me, unless I hear something different from y'all, is either the entry of an order of dismissal, which, as Mr. Howard correctly points out, would set that clock running for any claim that Ms. Cummings might bring for attorney's fees. Or you'll get a notice of another hearing, which means I've declined to dismiss it at this time. Anything else from me, or any questions about what we're going to do next, Mr. Howard?
One thing, Judge, on
Yes,
Monday, I filed a motion to dismiss count 4.
Oh, thank you so much. Yes.
The clerk's office has not entered it yet on the docket. I just didn't want you to see it come through and think that, after this hearing, that I was not listening to the court. It was filed on Monday.
No, I understand. I was actually I was at a Lawyers Club judicial thing last night, and I had 2 different independently on their own people ask me, so how long does it take for something to get accepted into the docket? I'm like, ugh. The best advice I have for you is that if you use is it Peach Pass? Is that what? No, it's not Peach Pass. That's what I use to drive in the fast lane.
Peach
What's
Court.
the Peach Court? If you use Peach Court, I will tell you, it takes longer to get into the docket. And the thing with Peach Court, not that they're not a great system, but for Fulton County, if you use Peach Court, it not only takes longer to get into the docket, but we can't see it. Whereas if you use Odyssey eFile or eFile Georgia or whatever, it may take a few days to get into the system, but we know it's there. When you email it to us, we can go into the system and see that it's there, and it just hasn't been accepted yet. That's the best information I have for you. So
interesting. Thank you.
Thank you. So in any event, if you will please, in conjunction with your motion, Mr. Howard, email a Word version of the proposed order of dismissal to the court, then we will go forward from there, and I'll be in touch with the parties next week.
Thank you, Judge.
Okay. Anything else, Ms. Jett? Mr.
No,
Henderson?
I'm good.
Okay. Thank you all very much. Have a good morning.
Thank you.
You too. Thanks.
Bye-bye.